Welcome, everyone. Um, Today, we have a very esteemed speaker that is going to be talking to us about beyond the headlines, the state of U.S. immigration today. She's going to be taking a practical look at the today's immigration policies and changes. And our speaker today is Esquire Rhoda Agyeman-Frimpong. She is an immigration attorney. She's the founder of Bethel Law Group, where she helps in people, families all across the country to navigate the U.S. immigration system. And she's a very, very accomplished barrister. And so, without much further ado, I would give it over to Barrister Rhoda to take over and enlighten us more about immigration. Over to you. Thank you so much, ma'am, for taking the time out today to enlighten us.
Oh, my pleasure. Good evening, Miss Esther and everyone else who's joining. Thank you for the opportunity. I always tell people that there are a lot of immigration attorneys out there, so whenever I get a call, I don't take it for granted. So I do appreciate the opportunity to connect with you all. I'm Ghanaian, but a small part of me claims to be Nigerian, Yoruba specifically. I have a name and everything, so I feel like I'm at home. But let's jump in. I know there's a lot going on in the news, and you likely have a lot of questions and you want clarification. And so that's what my plan is today, and that's what my goal is to inform you, to update you, to let you know what's true and what's not true at all. Am I able to do like a PowerPoint, or do you want me to just have a conversation with you all? It's completely up to you.
Yes, please.
I'm
You
able
can go
to
ahead.
share my
Yes, please.
screen. Okay.
Yes, yes. Go ahead and do a PowerPoint if you have
Awesome.
one.
All right, give me 1 second. Let's share this here. Okay. There we go. All right, are you able to see the screen? Are we good? Can you hear me? Can you see the screen? Okay,
Yes,
perfect. Good.
yes, we can see your screen.
Sounds good. All right, so we'll jump right on in. So a little bit about me. I am an immigration attorney, like it was said. I've been practicing immigration for a little bit over 10 years. I started while I was in school. So I've handled immigration cases from asylum to VAWA, so from A to V. I've done most of them. And my job more or less is to advise individuals, people who come to America for school and then want to stay and then make America home to build their families, or people who come and they want to work. And so most of what I'm doing now is what I do on the regular basis. And I find that the best way I can make impact for you is to answer the questions that you have. And so today won't be too much of me talking. I want to get to the questions and answer portion so that you can ask the questions that you have and I can give the information that you need so that this is worth your time. Okay. I am a first generation immigrant. I don't sound like it, but I was born in Ghana. I do eat like it. And like it was said before, I started my own practice called Bethel Law Group. It's in the Commonwealth of Massachusetts, but I represent people throughout the country and other parts of the world as well. So as long as it's U.S. immigration, I can help you. All right, so we'll jump in. I know that there's a lot that has been said and a lot that we're hearing. And much of what we hear and what they say isn't always new. And I'm saying that because I know most people in the United States come as either visitors or come as international students. And in more recent times, we've heard that, international student visa applicants especially are going under heightened scrutiny and their cases are being screen extra and vetting extra. And the fact is, most of this has already existed prior to this administration. It just so happens that this administration likes to enhance things and maximize the attention on things that already existed. Most people who applied for a visitor visa prior to COVID, so around 2019, you were putting on your application what your social media handle was. The form required it. So the request for social media handles on applications for international students isn't necessarily new. And I always say that those who have nothing to worry about are those who have nothing to hide. And so if there's nothing incriminating on your social media, generally you shouldn't have an issue. Another thing we're seeing that's changed in more recent times is the policy shifts. So in previous administrations, USCIS was somewhat more transparent. And immigration is one of the areas of law that usually is a reflection of whoever's in office. Okay, so if we have more of a liberal party in office, you'll see more liberal policies being passed, and vice versa. If there's a more conservative party in office, you get a lot more restrictive policies. Many of the policies that are in effect now or were supposed to go into effect have come through what we call executive action, where the president writes something and it has the effect of law. But what I want most people to understand, if not all people, is that simply because an executive order is signed does not mean it becomes law. About 2 days ago, I want to say today's Saturday, so I think Thursday, we saw that our president has signed another executive order attacking birthright citizenship. This is round two because he did that on January 20th, 2025, and earlier this actually we're in August now, so around July, excuse me, around June, Supreme Court came out and said, yeah, no, it's still going to be the law of the land. And so if you're seeing or you're hearing that executive orders have been signed, if you're seeing the media posting things, don't run with it as fact because usually within these executive orders, there are small exceptions. And more importantly, just because something has been written does not mean it takes effect. Because if it was supposed to take effect right after it's written, we wouldn't have birthright citizenship in this country right now, which we still do. Okay. One of the things that we're seeing in the news that is true, sadly, is that a lot of cases are being delayed, depending on what you're filing. So if you're filing a marriage-based green card, those cases are being processed at a rapid speed. I'm seeing, from the date of filing to the interview, it's about 3.5 to 4 months. Now, if you're filing for citizenship, for naturalization, you're looking at upwards of 10 months, which wasn't always the case everywhere. If you're filing for something like OPT, which is your optional practical training, after you complete school, that also tends to be taking a lot longer than it did in the past. And so, because of the first thing you see on your screen, because of the heightened scrutiny, because of the enhanced vetting, obviously, if an officer has to look at a document 3 times, it means that before he gets to the next file, it's going to take some time. So my best recommendation for anybody would be if you're eligible for something, file it as soon as you reasonably can. Because if it takes only 3 months now, that may not be the case in 6 months. It may take a little bit longer. And if it's taking 8 months right now, keep in mind that it could take longer than that. And so if you need something like a work authorization or you're trying to get a green card, apply as soon as you're reasonably able to. Okay. Now, right now, the most recent updates, which I say recent as in within the last week or two, is that the USCIS issued what is a policy that already exists, but this administration again has put it out as though it's something new. It's more or less, they're stating that USCIS, the agency that's processing your marriage-based green card cases, your citizenship cases, your work authorization applications, they're not required to send you what's called a request for evidence. So request for evidence is exactly as it sounds. When the government needs additional documents to make a decision about your case, they need additional evidence. So they usually will send you a request, give you a deadline by which you have to respond. And then after you respond, they make a decision based on what you sent them or if you did not send them anything. They also have something that's called NIWT. So it's a notice of intent to deny. Now that is when they're telling you we plan on denying your case because you don't appear to be eligible or because there are significant discrepancies in your case. And so we are tilting towards one end, but convince us why we shouldn't. Those are two documents or two requests that USCIS officers can send, and you get the chance to respond. This administration is saying that now they don't have to send those. They can just make a decision based on what's in front of them. So if the officer feels as though they don't have enough and they want to deny it, they can. Now, that's always been the case. But what this administration is announcing is that now the officer doesn't have to even consider the idea of giving you a request for evidence at all. They can just deny it outrightly. Officers can still choose to send a request for evidence if they want to. That's the part that they didn't say. So all that means for you, the person who's applying for anything, is make sure you have everything you need when you submit the application the first time, right? Most people, especially those who are filing marriage-based cases, think that they can just submit the application and then send the evidence later. No, you can't. You cannot, and it's usually not in your best interest to do that. You should submit the application when everything is ready to go so that you reduce your chances of getting a request for evidence. Because in the events that you get an officer who is not as gracious and they do not want to send a request for evidence or a notice of intent to deny, the law is saying that they can go ahead and deny your case altogether. And nowadays, if you get an application denied and you don't have status at the time of that denial, what I mean by status is, let's say you are a student, but your I-20 has ended, you've completed school, and you were filing a marriage-based green card. You were filing to get a green card through your spouse, and for whatever reason, the application was denied. If your I-20 has already ended and you're no longer in student status, you're considered out of status. And so if that application was denied and you're out of status, now what they do is they send your case immediately to court, which means you're now facing removal from the United States. And though it sounds intimidating because nobody wants to be in court, it's usually not the end of the world. Honestly, especially depending on your circumstance, depending on your case, you may have a defense even in courts. Okay. Another major thing that I have to bring up, is that travel right now should be something that you do with caution, whether out of the United States, but more importantly, within the United States. Most people who are undocumented know that you shouldn't go out of the United States unless you plan on not coming back for at least 3 or 10 years. Okay. But even those within the United States who have a pending application, maybe, like I said before, you came as a student, you've completed school, you've gotten married, your application for your green card is pending. And right now you're in limbo. You're in what's considered authorized stay. You don't have status per se, but because your green card application is pending, the law allows you to stay here. Those individuals are being detained in some airports across the country. Okay, like I said before, my office is based in the Commonwealth of Massachusetts. So Boston Logan Airport is our primary airports in that state. And just about last week, it was in the news that a young nurse who's been in the United States for quite some time, she filed for asylum and she has a work permit and she's allowed to be here while they process her asylum application, has been detained. And without knowing the full scope of her case, all we know is that she is allowed to be here while her application is pending. But despite that, she has been detained. And so for the person who is traveling domestically within the country, just be mindful that that could be a possibility. And I'm not saying it so that shut the door and say, I'm not flying anywhere at all, but just be mindful of where you're flying to. Because we are the United States of America, but the laws aren't the same in every state. Right. Some states like, Florida and Texas are not, sadly, immigrants friendly. So just be mindful if you're in Texas, which most of you, if not all of you are, just be mindful of where you're traveling and where you're going, especially if you're currently undocumented or out of status. Okay. All right. So this big one, international students, the rules are changing. Most, if not all of you who are students have an I-94. And on that I-94, there's something on there called the duration of status. Okay, the duration of status means that you are allowed to stay here in the United States for the entire time that you're enrolled in school full time. As long as you're maintaining your status and you are doing what you're supposed to do for school, you can stay here and just keep going to school without ever having to deal with or engage with the government. However, after September 15th, 2026, which is in about 5 weeks or so, this government is changing the duration of status to what's called admit until date. People who came to the United States on a visitor's visa know what that is. Because on their I-94, it says you're allowed to stay here until a specific date. It might be 6 months, it could be 5 months, it could be 3 weeks, it could be anything. But it gives you a specific date. Students don't have that, but going forward, they will. Now, what's going to happen for those who may already be students right now is that the Department of Homeland Security says they're going to update your I-94. So there's nothing you have to do unless you're leaving the country. But if you're still staying here, they're going to transition you to their new program, which means that what you see on your I-94 as duration of status is going to change to whatever the date is on your I-20. And so if you're here on a master's program, and your I-20, your program end date is 2028, you're going to get an I-94 that's updated to May 2028. Now, if let's say you're here on a PhD program, which is, let's say, 6 years, and this is the first year, you're going to get an I-94 that's extended up until 2030. The maximum amount of time that you can get as of September 15th is 4 years. So if your program is longer than those 4 years, you're expected to file an extension of stay application. Okay, so between now and September 15th, everything stays the same. But after September 15th, if you're coming into the United States, you're going to get this new program. Rather than the duration of status, your I-94 is going to say you're admitted until the end of your program dates. If the end of your program dates is beyond 4 years, they're going to only give you 4 years. Okay, if you're currently here in America, you're fine. They're going to transition you. Whenever they do that, only they know, they haven't said, but they're going to transition you eventually to the I-20 date. For those who may be on OPT, optional practical training, which is work experience after you finish school, the same thing will apply to you if you're currently in the United States and you do not leave the United States between now and September 15th. You will be able to stay in the United States without having to file for an extension of stay. So what that looks like in practice is you graduate maybe in December. The law allows you to file for your OPT at least 90 days before graduation. So maybe in September or October, you file for your OPT. Okay. It takes some time to process. Because you filed it before March 18th, 2027, you are fine. You don't need to file an extension of stay. What will happen is your OPT will be processed. If it gets approved, wonderful. You get to stay in the United States for the length of time that they give you. Okay. If you decide to go to school after you complete OPT, you'll have to file an extension of stay at that time to continue staying in the United States. Okay. I'll have time for questions at the end if that's confusing, because most people get confused with that portion. All right. Another major change as a result of this program, and again, it doesn't take effect until September 15th, and it's a possibility that it may not, they say. The only way that this may not take effect is if Congress does something, which again, we don't see that happening, or if a judge decides to render a ruling that puts an injunction on the putting this into place, but we don't see that happening, but we'll see. Okay. But if it does go into effect September 15th, undergrads, those who are applying for bachelor's and below, your first year, you cannot change your program. You cannot transfer schools. And this may not be an issue for those who are already in the United States. It may be a bigger issue for those who are coming to the United States. And so if you know family or friends who are looking to come to the US for school, this is information that they need more than perhaps you. Because sometimes people are coming to the US, they apply for a student visa, and they're looking to come into the US just so that they can get in here, right? They just need a visa. They probably put on the school application that they want to major in statistics. But math is like west and east for them. They and math don't get along. But in their head, I just want to get in and I can change. If you're an undergrad, your first year, you cannot change. You can't change schools and you can't change your major your first year. You may be able to do that second year onward, but you can't do that your first year. Graduate students cannot change your program at all. So if you enter the United States as a graduate student, you're coming to get a master's in finance, you can't change schools after arriving or starting, and you can't change your program. So if you decide, I don't like master's of finance anymore, I want to go do something else, maybe I want to consider nursing, you can't do that. Once you start the school, you start the program, you can't transfer. It's restricted under this new program going forward. Another major change is that you can't scale down. If you have a master's degree, you can't study for a bachelor's. You can't study for another master's either. So no lateral degrees. So it's only upwards. So if you have a master's, you can study for a PhD. If you have a bachelor's, you can study for a master's, but you can't have a master's and study for a bachelor's, and you can't have a PhD and get another PhD. Now, as to what it's going to look like for people who perhaps have a PhD in psychology and want to pursue a law degree, because both are the same degree level, that's yet to be determined. Because within the regulations, it says that they're still working out how that's going to play out. It's still uncertain at this time. But that's something, again, because this is a very new rule, and I want to say since 1978, don't quote me on the specific date, but since around that time, the duration of status has been the law of the land. That's what it's been for international students for years. So this change is going to be a drastic one. Implementation is still yet to be determined, even by this administration. Okay. All right. Another big thing that's affecting most people, Nigerians included, is the 39 country travel ban. Now, I'm sure most of you already know about it, but I'm bringing this up because most people get confused with how this is applied. The travel ban affects those who are outside of the United States. So if you have someone who ironically is trying to apply for a student visa, they wouldn't be able to get one anyway, because Nigeria is subjected to a partial ban. And it only affects B1, B2, and F, J, or M student visas. It does not affect a visa like an O1 or a P visa. The partial ban only affects the visas that are specified within that actual ban and within the rule. It does not affect other visas. Now, what may affect other visas is the 75 country visa issuance suspension. That, however, only affects immigrants' visas. So if you're in the United States and you're filing for your mother who's in Nigeria, you can go ahead and submit the petition. It'll get processed. It likely may get approved, and the case will continue on to the next step, which is the National Visa Center. So they'll allow you to submit your tax documents. Your mother can submit the visa application, pay all the necessary fees, perhaps even do medicals, police certificate, and everything. May even be scheduled for an interview. However, she will not be issued a visa because that's what the suspension says. So it's an interesting way that they're processing. And the question most people ask me is it even worth it to go ahead and file if she's not going to get the visa? The answer is generally it's up to you, but I would recommend to at least file because there is a processing time that you have to take into account. And so you might as well make good use of the time that you have while you're waiting for this suspension, hopefully to lift. Okay. There's also, again, the visa bond, which unfortunately Nigeria is also one of the countries that are subject to this bond, but Nigeria is also on a restriction, so no one's really getting a visitor visa anyway. Okay, but more or less what that visa bond says is effective January 21st, if you're applying for a B1, B2 visitor visa to come to the United States and you attend an interview and the officer wants to grant you the visa, you may be subjected to a bond. You would have to pay either $5,000, $10,000, or $15,000 at the discretion of the officer in order to actually get your visa. I'm not going to spend too much time on this right now because most people aren't able to get a visitor's visa from Nigeria anyway because of the 39 country travel ban. All right. But it is sadly something that does exist. Okay. Now, another change that affects specifically Nigeria is that for whatever reason, the Department of State is consolidating their embassies and consulates. And so the Lagos embassy is still open. However, they say they're realigning their routes, their procedures and processes such that individuals in Nigeria who have to attend visa appointments will now have to go to either Abuja or another designated hub. Okay, and that affects individuals who are applying for, again, tourist visas or immigrant visas. Currently, because of the 75 country suspension, immigrant visas aren't being issued. And again, because of the 39 country travel ban, visitor visas are not being issued. So this, again, though it exists, doesn't impact you all, at least not right now. Okay. All right. And that is all I have for, they told me 30 minutes of talking, and I think I saved 7 minutes of that time. That is my information there on the screen in case anybody does want to connect with us after. If you scan the QR code, it does take you to our contact information where you can save it. It also does take you to our Instagram page. I'm not asking you to follow me. I just want you to save that page because that is where I post most, if not all of the updates that happen. So whether it's birthright citizenship, whether it's the international students program changing, whether it's travel advisory, whatever it is that my fellow Nigerians or immigrants need to know, we post it on that page. And so if you want to stay updated, it would be a good idea to at least save the page or follow the page. Okay. I'm all set over to you. So now I can answer
Thank
questions.
you. Thank you so much, Barrister Rhoda.
My
So now
pleasure.
uh, the floor is open. If you have any questions, feel free to go ahead and ask her or put it in the chat and I will read it out to her. So we do have a question. Someone said many Nigerians are transitioning from F1 OPT to H1B or employment-based immigration. What should they be doing differently under the current environment?
The biggest thing for F1 students is to maintain status. And maintain status sounds easy, but something as simple as doing Uber can cause you to violate your status. And it's the federal government, they can easily find out. Right. And so if you're looking to do a change of status, maybe you finish school, you do your OPT, and you have a company that wants to file for an H-1B for you. The company can do all its part, successfully. But if you're not eligible because of some indiscretion or some immigration violation in your past, that option is no longer available to you. So the biggest thing I would say is if you're in school, attend school, maintain the grades, maintain the status, do not work without authorization. I get times can be hard and things can get difficult, but if you're thinking the long run, is it really worth it to sacrifice that? So that's the biggest thing I would say.
Thank you very much. Another question that someone sent, they want to know if, with the ban that they're having on Nigeria, if someone
Mhm.
who has filed for a based visa or VAWA has a kid that's in the application, does that affect the kid? Is the kid able to come over to the US?
So there's a slight exception within the rules. If the person is coming to the United States with an immigrant visa, however, they would not be able to. So the child is in Nigeria
Correct.
and the parent is here in the United States and they're adding the
And
child
and
to
they
the
filed for a marriage based visa. So if they get
Oh,
approved the ban, will the child still be able to come if their
no.
visa gets
So
approved?
no. So it's still an immigrant's visa. So because what will happen is that the approval would have to be sent to NVC, then the individual has to go to the embassy for the interview. And so they may be able to go to the interview. They likely will just fine without a problem, but the embassy won't be able to issue an immigrant visa to the child. So the fact that it's a child doesn't really make much of a difference, sadly.
All right. Thank you very much. We have another question. How does the DOCAS ruling of June affect Nigerians adjusting status inside of the United States? And is there any update on that case?
So any of the suspensions that affected the countries, either the 39 or the 75, don't affect individuals in the United States right now. So even if you're Nigerian and yes, at one point earlier in this year, up until about June or so, if you're from any of the countries under 39 country travel ban, USCIS said that they weren't going to process your case. Though you're here and you're eligible, they just put a pause on adjudication of those cases. As of June, those pauses have been lifted within the United States. USCIS has been lifted. The ban still exists, but if you're in the country, you can still proceed and file and get your green card. We've gotten a few green cards for people from countries who were initially banned. So it's if you're asking me how is it changing or how is it affecting adjustment of status, people are getting green cards. Yeah.
Another question, what happens if you lose your job on a work visa and how much time do you have?
If you lose your job on a work visa, it depends if it's an H-1B, as in if you're terminated or you quit. There's
Correct.
two
If
different. If you're
you got
terminated,
terminated and you have H-1B.
you want to find another job as quick as possible so that you can hopefully port your H-1B status. So what will happen is if you find another job, another employer would have to file the H-1B petition. Once they receive their receipt from USCIS, you can start working for them. But if you're here, if you lose your job for more than 60 days and you're unemployed under H-1B, you have no choice but to leave the United States, sadly. And your employer does inform USCIS when they terminate you.
All right. Keep the questions coming. Somebody said, Mother is a US citizen. Can she
Okay.
still file for my father with the current situation? She's currently in Nigeria.
Yeah, so if mother's married to father, she can file for her spouse. She can. It's just that unfortunately, as of right now, the 75 country visa issuance suspension I'm being a little bit optimistic, may get lifted. We don't know because there's another case where the individuals filed a lawsuit challenging that 75 country suspension. And they won. And the judge lifted the suspension as it relates to the parties in that case. So in a way, in the legal space, that's good because that sets a precedence for everyone else. So there's currently another case where it's seeking a nationwide injunction. That case is still pending. We're hoping to get some sort of an outcome on that soon. I say all that to say, if your mother wants to file for, your father or her husband, she should go ahead and do that. The suspension, fingers crossed, God willing, one day will be lifted. And so because petition time is taking almost 10 months, it makes sense to file it so that while we are waiting for the suspension to lift, you at least have that application pending and processing.
All right. Thank you very much.
No
Another
problem.
question. If someone has a valid visa but is questioned extensively at the airport or port of entry, what are their rights and how should they respond?
Good question. So you don't have as much right standing on that side of the border. When you enter the United States, that's when you have a little bit more rights. Because at the border, the nation's interests supersede your right to privacy. If you are being asked questions, it's likely what I mentioned during the presentation, heightened scrutiny. And it usually could be because of the country you're coming from, or the frequency of your travel outside of the United States, or something within your immigration history is inconsistent. And so it'd be the best way I would advise that person is to find out what it is that keeps triggering these inquiries. If it's frequent travel, then you may want to sit tight for a bit and not travel as often. If there's something in your history, immigration past or filing, you may want to find out what that is so that at least you have documentation. If it's a criminal involvement, that's pretty serious there. But you want to always travel with documentation that the court case has been resolved, has been dismissed, or whatever the outcome of that case is. But without knowing specifically what they're stopping you for, it's hard to really guide you. But you unfortunately don't have as much rights. If they need to check your phone, they can. If you're a U.S. citizen, you can tell them no. If you're not a U.S. citizen, you don't have as much rights. They can deny you entry unless you want to comply and give them your phone. So it's more of a judgment call at that point.
Thank you very much. With the current immigration rule, will there be any implications for a PhD student who decides to leave the program early and graduate with a master's degree instead? That's a good one. That's a good one.
Yeah, I
We
had
see that
someone
a
else
lot.
ask me that question today. So you basically try to circumvent the process and give yourself a second master's. Uh, I'm curious as to how that's going to play out. I don't see that playing out well within this new framework, primarily because you would end up with a dual degree. You'd have not dual, you'd have the same degree you already have. So dropping out of the program would ultimately warrant you, you've ended, you'd have to leave the United States. Because if you decide to stop, your school has to inform ICE, right? And many students don't know this, but the ICE agency is the one that runs the Student Exchange Visitor Program. So the SEVP, SEVIS, all of that is ran by ICE. When you drop out of status, when you drop out of school or your school cancels your I-20, it's ICE that they're informing. And so I likely wouldn't want to risk that, especially if they're saying if you've completed a master's, you can't get another master's. You would more or less be violating the law with the same agency that's responsible for enforcing the law. So yeah.
So if you, I'm asking a follow-up question. So if you
Yeah.
complete a master's and you apply for another master's and leave the country, get another OPT, is that possible? Because I did that. So that's
You
no longer
likely
possible.
not after September 15th. So you got one master's, you completed OPT, left, and came back, you said?
I just went to a nearby country and just renewed my I-20 and came back
For
and
another
started the other one.
master's.
Yes.
Yes, that's
So
perfectly
that's no
fine.
longer
That's perfectly fine. Many people have 3 or 4 masters for that exact reason. You just want to buy time to stay here in the United States, but that's no longer
to buy time.
possible
Yes.
after. Yeah. Yeah, and the reason why they're taking that away is because they have determined that people are doing that to stay here in the United States longer. And currently, if you want to, continue education, a person can come to the United States in 2000, let's say 2013, and work all the way through their education and never have any interaction with the federal government. Because once you come into the US on an F1, all you need is a valid I-20 to keep going. And so let's say you get your bachelor's, that's 4 years. You get another I-20 for your master's, that's another 2 years. You get another I-20 for another master's, that's let's say now 8 years that you've never interacted with the federal government. And from their perspective, they're not okay with that because they want to be able to rescreen, they want to vet, they want to make sure that you're actually attending school and that you're not using the visa as a means to stay in the United States and do something else. So unfortunately, that won't be possible anymore.
Now, given everything you have discussed tonight, what are the three most important things Nigerians in the United States should be doing right now to protect themselves and their immigration status?
If you're an international student, I would say document everything that you're doing as far as school's concerned. If you're writing papers in school, if you are, doing some sort of research, and I say that only if your end goal is permanent residence in the United States, right? Because when it gets to the completion of your program, when you complete that program, you only have but a few options: go home, work, or get married. And if getting married isn't something that's on your radar anytime soon, then it's either going to be an employer filing for you or returning home. And the ability for an employer to file for you or even for you to file for yourself will rest on the documents that you have. So let's say you want to consider something like an EB-2, national interest waiver, it's going to take the documentation that you have. How do we prove that you have these qualifications? Your documents. Or if you even want to go for the gusto and apply for an EB-1A, right? How do we know that you have extraordinary ability? Your documentation, your publications, letters of recommendation. So that's the first thing. Keep documents. The second thing is make sure that you're getting correct information. I've had people who have made some hard decisions on incorrect information, and most of it can't be corrected after the fact. So make sure that the information that you're making decisions on are correct and they're valid. And if you're going to travel, it's in your best interest to speak with an attorney before you travel. Internationally. Domestically, you should be fine, provided your I-20 is okay. If you're traveling outside of the United States, because sometimes I have people ask me that, oh, my passport has expired. Can I go back and come back and get it so I can get a new visa? The visa only matters when you're sitting on the border. When you're seeking admission, that's the only time the visa matters. So you can be in the United States with an expired visa, and that's perfectly fine. But if you say you're going to return to Nigeria just so you can get a new visa, you can't, especially if it's going to be an F, an M, or J, or a B, right? You're leaving to get yourself stuck. So if you're traveling, and sometimes the traveling is inevitable, the situation demands that you travel, but still try to talk to an attorney to see what options are available to you.
So I have a follow-up question about that EB2. I know a lot of people don't know this. I didn't know this. That's how I
Yeah.
got my green card.
Okay.
So maybe if you can shed more light on it, so our communities can know about it, because there are a lot of people that have their master's degrees, they have PhD, and they don't
Hmm.
know they have that option to get a green card with that.
Yeah.
And so, has there been any changes to the EB2 policy? And I think it'll be a good idea for you to shed light on what that is and how
Yeah.
students can get their green card using that.
Do you know what? Let me
That's
see if I
that's
can
how I
pop
got mine.
open. Good for you. I'm very curious to know what your proposed endeavor was. But maybe we'll talk about that some other time. If you give me 1 second, I can open up my presentation for that. That way I can break that down a little. Because I think explaining EB2 is better visually than it is just talking about it. Okay, give me a second here. All right, can you see my screen again?
Yes.
Awesome. All right. So EB2 NIW is National Interest Waiver. It's part of the EB2, the employment-based process, but it's a second category. So employment-based process has about 5 different levels. There's the EB1, which is extraordinary ability, or maybe you're a great professor or researcher and an institution wants to file for you, or you are an executive in a multinational company. That's EB1. EB2, under that, there's 2 tracks. There's one for an employer wanting to file for you because you have a master's degree or higher. Or there's you want to file for yourself because you have a great idea that's going to impact the country in some way. The first requirement for EB2 to even be EB2 NIW to even be an option for you is an advanced degree. And that's usually a master's or higher. Or if you don't have a master's, you have a bachelor's degree and 5 years of post-bachelor, program work. So let's say you graduated 2010, and then you worked for maybe 5, 6, 7 years after that. Then you may be able to consider an EB2. If you only have a bachelor's and not enough of the 5 years that's required, then that's not an option for you. Your best option is to get a master's. If neither of those apply to you, the other option is if you have what's called exceptional ability. Now, exceptional ability is somewhat of a higher standard in the sense that you have to show you have at least 10 years of experience in the field, coupled with letters of recommendation, a high salary. You're more or less exceptional in your field for that to be the route you want to take. Because most of the people who are applying are coming out of school and don't have the 10 years experience, they just look for the advanced degree option, which is, like I said, a master's or higher, and you're good. Once you've fulfilled that section, the next one is, what is your idea? Because the US government usually requires individuals who are coming here under the employment route to have an employer to file for them. And so if you're asking the government to waive that job offer, that employment process, you have to explain to them why. And the reason why is because you have a great idea that's going to be a benefit to the United States in some way, right? That's number one. The second thing is, are you in the position to actually advance that idea? So the best example I can give, let's say that I've been practicing immigration for 10 years, okay? I have my practice for about 8 years. I'm applying for EB2. And they asked me, okay, do you have an advanced degree? Well, I have a Juris Doctorate degree, so that's done. The second thing is, what is your proposed idea? Well, I can't just say I want to be a lawyer because they can easily say, well, go apply to the other 1,600 law firms in your state. right? So why do you not have to just apply to another law firm? Convince us why we shouldn't require you to do that. I would say, well, I'm an employer. Okay. Rather than having me work as an employee for someone's office, I can rather bring jobs to the United States. That's number one. So it's something that's of substantial benefits. National importance. Let's say that I'm creating a law firm where we only serve the underserved populations in rural areas. Now you've gotten someone's interest because you're making impact in a specific industry in a specific area. Okay, the next thing they'll ask me is how well positioned are you? How do we believe that this brilliant idea you have, you actually can bring it into fruition? Well, I've done it for 10 years, so I think I can speak for myself when I say I can do it here. So that's what you would have to demonstrate to them. And so the last thing, which would be show us why we shouldn't require you to get an employer. Like I said earlier, getting an employer would mean I'm only working for one person and the benefits and the ideas that I have is only for one firm. Whereas if you allow me to be the job, right, and not be subjected to one employer, I can impact, I can give jobs to other employees, I can serve other areas. It becomes a benefit to the United States. Okay, so that is in summation what the NIW process is. The best advice I can give anybody who's considering this path, look up and search what is America's pain points. What are the areas in this country that are problematic? Healthcare is usually one. Now we're in a days of technology, right? How about the merger of AI and something with health, depending on what your degree and your background is, right? Like I'm not a science person at all. But let's just say if I was to be a science person, okay? Maybe, how we can use AI to detect early signs of dementia, right? Maybe some machine takes someone's blood and can see 20, 30 years down the line that you may have signs of dementia. And so we start treating it when the person's 25. And then we see a drastic change in that by the time you turn 60, there is no dementia. You're likely going to get an NIW for that because it's a pain point in the United States. Okay, so search where is the US struggling? If it's tech, if it's finance, the finance field, if it's healthcare, if it's even children. And then how does that connect to your degree? And then how has what you've done in the past, your experiences, your OPT, your STEM OPT, all of that, how has that put you in a position to now advance this idea that you have? I think I'm done.
Thank you very much. I'm going to use myself as an example. If you're a student, while you're still in school, try to publish papers.
Yeah,
So those papers that you publish is something that you could use to file during your OPT. Do very well in your whatever company you're working on. Have bright ideas. Keep record of everything that you're doing. So it'll be part of the evidence that you can use to show that you qualify for the national interest waiver. So
right.
our next question. For Nigerians planning to invite parents or relatives for graduation, weddings, childbirth, or other family events, what has changed regarding visitor visas?
They can't come. I'm sorry.
Yeah.
39 country travel ban says they can't come. They can't get a visa unless they're dual citizens. So, if, mommy, daddy, auntie, cousin has, a British passport, hey, then they're not Nigerian, they're British. And so there's no suspension or ban affecting them. But if they only have the Nigerian passport, unfortunately, they won't be able to get a visa to come to the United States, at least not until the suspension is lifted.
And our next question, what is one immigration issue affecting Nigerians right now that you believe our community is not paying enough attention to?
Ooh, that's a good question. I don't know if there's an issue that our community is not paying attention to, because if there's any community that is staring and locked in with immigration, I think it's almost all Africans, should be told, right? I think I only ever encounter situations where people are a little oblivious to the immigration process is when I'm dealing with employers who are filing for foreigners. But for the most part, most immigrants know what's going on. What is one issue? That's a hard one. I don't think. Ooh, actually marriage, the marriage process. I think too many of us are overly confident in our ability to prove the legitimacy of our marriages. Or we underestimate just how far immigration will go to fact check whether the marriage is real. It's the federal government. Nothing will stop them. If they want to put your case on pause and go and ask your neighbors for the next 6 months how often you come to that house, they can do that. If they want to show up at your job and ask your employer to provide your documents, your application when you filed for that position, when you applied for that job, if they want to review all of that to see if your address matches what you put on your application with USCIS, they can do that. So I think I would say that's one thing that we're not focusing on too much. And I say that because the stakes are really high, right? It's not just a matter of I marry a United States citizen, I get a green card. No, if they suspect that your marriage is fraudulent and they state that this is a fraudulent marriage, if you divorce that person, let's say you even get married to Donald Trump's sister, you still can't get a green card because there's something called a 204C bar that prevents you from getting a green card if the government has determined that you tried to get a green card through a fraudulent marriage. So I would say that is one thing that I think we underestimate just how far the government will investigate, and we overestimate just how much evidence we think we have and how strong our case is. Because I've seen genuine marriages be denied. Genuine marriages. Yeah. Good
And
question.
I have a follow-up question to that. I remember there was a policy that came out recently where they said if you've taken any government benefits,
Mm,
that gives them the right to deny you. So that would include people taking things like food stamp, WIC, and all that. So
hmm
if someone that is taking a health benefit, so maybe someone that is like a dialysis patient and is
hmm
getting free dialysis from the hospital, and they have a marriage-based green card application, is that something that could hurt their case? Is
It
that considered as
depends.
them taking government benefits?
So the term government benefits is very broad, and there are only a few actual benefits that number one, non-permanent residents can even qualify for. Most non-immigrants, let's say visitor visa or F1, or you're in the process of getting a green card, don't qualify for many of the benefits that would make you public charge. That's number one. Now, the services or the government assistance that would make you a public charge are things like long-term care as far as institution is concerned. So the dialysis patient, if they're in there for an extended period of time, let's say and the government is paying for this, then yes, if that person is going to be applying for a green card, they may be considered a public charge. But getting things like food stamps and WIC, generally non-immigrants can't get that. Now, if you're applying for those things for your children, who are US citizens, you're not the recipients of that benefit, they are. So I think oftentimes we hear that if I get any benefits, I can't get a green card. If your spouse is the one getting the benefits, that doesn't affect you. If you are the recipient, the person applying for the green card is a recipient of a government benefit, a qualifying government benefits, then you become a public charge. So let's say it's something like cash assistance, which again, most people don't qualify for, right? So if you're getting cash from the governments, then yes, it's considered that the government is sponsoring you and you're a burden to the government, so you're a public charge. But if it's for your spouse, if it's for your children, and it's not directly in your name, then no, it doesn't affect you.
So in that example I gave you, where the dialysis patient is married to a U.S. citizen and
hmm
they're the ones getting that dialysis benefit, they
Who's
are
getting the
considered a
dialysis benefit?
public,
The U.S. citizen or the
no, the
actual applicant?
non-U.S. citizen.
The non-U.S.
So they
citizen
will be
getting the
considered a public charge.
if they're in a long-term institutional care that the government is paying for fully, then yes. Then yes, which I'd be curious to see how they are even getting that benefit, right? It likely might be through their spouse. I would, again, the lawyer in me wants to read the fine print to make sure that they are the direct recipients of that benefit before I'd say they're outrightly that they're a public charge.
All right. Um, can someone's visa be revoked without them realizing it? And how can they verify their visa status before travel?
Can the visa be revoked if they're in the United
Without them
States?
realizing it has been revoked. And how can you verify your visa status before traveling, if that's
Generally,
true?
if they revoke your visa, they let you know, generally. But if you wanted to find, you usually would get some sort of correspondence. Now, because they send you, off the top of my head, I'm forgetting the actual law, but there's a thing, is it two? I don't want to make it up. But there's a specific law that allows the governments to revoke if later on they determine or they find out something sketchy in your past, right? So I've had people attend an interview, get approved, get the visa, and later on are sent a notice that on second thought we're taking it back. So yeah, so it would depend on what it is, but either way, you would get correspondence from them. It's not an arbitrary thing that you just guess.
What happens when an F1 student accidentally works outside the authorization permitted by CPT or OPT?
You violated your immigration status. And it depends on what you're trying to do going forward. If, let's say, you are looking to file for a green card through EB2, NIW, or you're trying to get a green card through an employer, you risk a possible denial. Now, if you're getting a green card through marriage, then you'll be fine because more or less they'll forgive you violating immigration laws if you're married to a United States citizen. The only laws that they won't forgive is if you say you're a US citizen when you're not. But if you work without authorization and you're married to a citizen, they'll look the other way, sort of. But if you are, let's say, applying through an employer, then that becomes an issue. Then you become inadmissible because of that.
Another question, if someone applies for a marriage-based visa and they call them for an interview without sending the work permit, is that a normal?
That's
Is that
very
something
typical. Very.
typical? Okay.
Yeah, so in recent times, that's become very normal. I haven't seen a physical work authorization card, and I think we're in August, almost a year, because the green card interviews are being scheduled a lot faster than the work authorizations are being processed. And most of the time, people actually want the green card. They don't really care much about the work authorization, so no one complains about that. But it's very normal.
Okay. All right. Um, what should Nigerian families with children approaching age 21 know about aging out of dependent immigration status?
Mm. So it depends on what the parent is currently. What's the status of the parent? So if the parent is, let's say, an F1, and the parent's here as a student, once that child turns 21, they're no longer considered a minor. They're no longer a child in U.S. immigration law. So they would have to find their own status. Either that child is going to have to apply for their own F1, meaning they have to apply to school, get in, and then get the I-20 and go through that entire process, or that child has to leave the United States, but the child will no longer be under the parents. Now, if let's say the parent doesn't have status and the child is 21, and the child also doesn't have status, the child will start accruing unlawful presence. It gets a lot more complicated for them up to that point. So it all depends on what the parent status is.
If someone's immigration petition has been pending much longer than normal, when should they seek legal intervention rather than simply continue waiting?
Depends on what is much longer than normal. That's the thing.
What would you consider longer than normal?
For a marriage-based green card case, nowadays, I would say maybe a year, especially because the cases are taking about 3 to 4 months. But a year beyond that. If it's OPT, like it's a work authorization, that's taken almost 10 months. Back in the day, it used to be 4. So I would say check online to see, and the online case processing information is not the Bible. Use that when your discretion. It gives you a general idea. But it does say 80% of cases are processed within a specific time frame, which presumes that there are 20% that are processed either earlier than that time frame or later than that time frame. But it's hard to specifically say what is longer than normal. So
Okay, thank you so much. Can a US citizen still file for a non-citizen sibling? What is the wait time?
yeah. U.S. citizen can file for non-citizen sibling. It's about 17 years.
Wow.
Yeah. Yeah.
Um, if a person has an MBA and is a registered healthcare professional, do you think there can be strong case to apply for the EB2 NIW, even though the MBA might not be directly related to the healthcare profession?
I would need to know what your proposed endeavor is. So it's not simply just that you have the degree, but what's your idea? Now, if you have an MBA and you're a healthcare professional, so is your endeavor connected to your degree? I have questions about that. That's hard to answer, right? So if your MBA is just a random degree you have, but has no correlation with your proposed endeavor, then what gives you the advanced degree requirements? How do you meet that? Because the advanced degree has to relate to what you're trying to do.
So a follow-up on this person's question, does that mean the only people that can use the NIW are people in STEM, like science, technology? Can people in the arts also apply for it?
You absolutely can. Yeah. So it's not the STEM majors have a slight benefit because their fields are priority right now. It's a hot topic, right? You're talking about technology, AI is everywhere, engineers, same thing, right? Math, you're talking about, let's say, actuaries and sciences, it's a given. All kinds of healthcare, jobs and opportunities there. So they have, I won't say it's a guaranteed route, but they have a stronger route. Um, Liberal arts depends again on what your idea is. right? Depends on what your background. At the end of the day, as long as you meet the requirements as far as a degree and you can curate or narrate your plans well enough that America cares about it, you should be good. So I won't just say it's only for STEM.
On that, I did have someone who, when they came here, the person that told me about the NIW, they had, I think, about 14 years experience before they came to do their master's degree. And I think
Nice.
they used that as part of, uh, to add to their case that this is
Hmm.
the evidence that I have a lot to offer the US. So
Absolutely.
I,
Yeah, they definitely
I don't
can
know.
establish,
Their
a
prior
bit of,
experience.
yes. Yes.
So,
Ability to advance the endeavor. 14 years of doing something, you definitely have that ability.
yeah.
Yeah, that's good.
Right. And the next question, what's the success rate of the EB2 or EB1 cases you filed recently?
Recently, I haven't recently. I've not taken EB2 and EB1 cases. I'm basically immersed in court cases right now. Yeah. So right, because unfortunately, like I said, if someone files something and they don't have status, it's straight to court. So a lot of people are calling me for court cases. So reason I have not taken an EB2 all year. And it's not looking like it's gonna happen. So I can't, it's hard to give that answer.
All right. Another question. If someone is already in deportation proceedings, is there any hope? Is there, and have you ever seen a situation where that can get turned around and they eventually get a visa?
Yeah,
Give an
absolutely.
example.
One of my clients is on her way to citizenship right now. And she was ordered deported in 2018 before I started my practice. So is there any hope? There's always hope. And in some cases, some people have a better chance when they get in courts, ironically, than when they're not in courts. Because there are some defenses and forms of relief that are only available to people when they're in court. There's something called cancellation of removal. It doesn't exist for anybody unless you're in removal proceedings, and usually requires that you're in the United States for at least 10 years, right? So you've been here for 10 years and you've been laying low, and for whatever reason now, immigration is looking for you. If you have, a qualifying relative, right? Let's say you have children, or you have a spouse, or you have a parent, you can file for cancellation and removal and you can get a green card through that. The case that we had, we've had a few. The most recent one was she came in 27 years ago with someone else's passport and visa. She still had a copy of the visa and passport. And we were able to more or less ask for a waiver. Her daughter turned 21. Her daughter filed for her. Her mother also came to the United States through one of her other siblings and became a citizen. So we had two qualifying relatives, a U.S. citizen parent and a U.S. citizen child and other minor children. And yeah, she has her green card. She's applying for citizenship soon. So
All
not
right.
all hope is
Another
lost.
question. Has there been any updates to the VAWA visa policies? People that are doing VAWA
Mm.
getting approved. Do you know of any updates to those policies?
Yeah. So VAWA, sometime earlier this year, I want to say, if not last year, became another hot spot for this administration. So usually, VAWA, so for those who don't know, VAWA is Violence Against Women's Act. Though it says women's, it's for men as well. Individuals who have become victim of abuse or extreme cruelty in their relationship, either through marriage or by a parent, okay, or even sometimes a child. If you are the parent of, or the spouse of, or the child of a U.S. citizen or a permanent resident, you can file for VAWA, and the purported abuser would never know because the law protects your information, protects your identity. The key thing, though, is you'd have to prove that if it was a marriage-based abuse, the marriage was real. Now, the changes that I've seen more recently is that they are calling individuals in for interviews, which isn't something that they always did in the past. If your case was strong enough and you can establish that you were in a genuine marriage, and then you actually suffered abuse, whether it's physical, emotional, psychological, financial, or some extreme cruelty, they usually would approve your I-360 and then you file for your green card. But right of late, and it's because I think early sometime this year, sadly, the person was from Ghana. So this one day I have to claim Nigeria. I'll be on Nigeria's side for this part. But a Ghanaian lawyer in New York was investigated, and it turned out that he had abused this VAWA program for many people just so they can get work authorizations. And shortly after that, USCIS started, requiring individuals to attend interviews for this. So that's probably the biggest change for VAWA.
Okay. Our next question, please, I need advice on this. I'm filing for my wife, which she already had filed before we met, but she never got called for interview. So after our marriage, I filed for her and we were called for interview. And she was asked a lot of questions about the old marriage for hours. After the interview, she was sent RFE, which we replied and later got a denial letter for the old marriage. And now we asked to come for another interview. Please, any advice?
What state is this? This is risky. This is risky.
Probably, most
Um,
likely Texas, because
yeah,
the person is in Texas.
yeah, this is risky. Because and I'm sometimes, some states, Texas included, can have individuals detained at USCIS interviews. So yeah, okay. If it's Texas, then you're saying that she filed before. So she was once married. Okay, there's a lot of information missing here, but I'll try to see how best I can answer this. So she was once married, and you didn't know about the marriage, it sounds like. So she filed, and it sounds like that application was either still pending or there was no decision on that application. That information is unclear. And then you two got married, and then you filed for her. If the first application wasn't approved or the decision wasn't made on that, that's going to be an issue. That's number one. If she never divorced that first couple, then your marriage to her is not a legitimate marriage because you can't be married to two people at the same time. And so your application for her likely will be denied and it's considered invalid because your marriage is not valid because she's still legally married to somebody else. So I need a lot more information to figure out how best I can answer this question. But I would definitely call an attorney. She was divorced. Good, that's helpful. And you have a divorce decree. They likely have questions about the legitimacy of that first marriage. And I'm hoping that they don't think it's a fraudulent sham marriage. Because if they do, then your ability to file for her won't be successful. They might approve the I-130, which is the application that says you're a citizen and she's your wife and your marriage is real, but they won't be able to approve the green card. The first marriage was denied. I would have to know the reason for the denial. If it was denied because they thought it was a fraudulent sham marriage, then she might be barred. Might be. Okay, so if you know the reason why that first one was denied, that would help. But if they're calling for a second interview, I would definitely go with it. Talk to an attorney before you go. Talk to an attorney before you go, because you're in a state that isn't, it's not uncommon for them to pull surprises.
I know we're at the top of the hour. One quick question that I'm sure most people would like to know. What would people expect to pay for a lawyer for the price range for most cases so that our communities can have an idea on how much it'll cost them?
So that's a hard question to answer because it depends on the service you're looking for. It depends on the details of your case, right? If a person, let's say someone who came to the United States on a DV lottery, right? I know most Nigerians unfortunately don't qualify for that, but let's say you came here, green card lottery, you got your green card, you've been here for 5 years, no crimes, you paid your taxes, no issues, nothing. You're filing for naturalization. I cannot charge you the same price I charge somebody who got their green card through marriage. The green card was denied a couple times. They are behind on their taxes. They also have a child with someone else while they were married, and now they want to file for citizenship. You're not going to have the same price because there's more complexities with the second scenario. That's number one. Number two, every case is different, right? And our prices are a reflection of the work that's involved in the case. So it's hard to answer that question. And number three, the state that you're in also can determine the prices that you're going to pay, right? Some lawyers that are in, let's say, some rural parts of the country may not charge as much because the cost of living is not the same. And we also are bound by ethical rules that we must charge reasonably within the market. Okay, so let's say if I'm in Boston area and I'm charging $15,000 for a marriage-based green card, you better believe that's a violation of the law because maybe the average firm is charging maybe 7,000. So all of those things are factored into the pricing. But if you're asking me for consultation rates, I can give you that. All right, our consultation for a 30-minute phone call is $150 for 30 minutes. For a 45 minutes, either phone or Zoom like we're doing now is $200. And then for a 1 hour session, if you want to fly down to Massachusetts in office is 250. 250. So yeah,
Well, thank you so much, Barrister Rhoda. This was a very enlightening session.
my
Unfortunately, we
pleasure.
can't take any more questions. We're past the top of the hour. If you have any more questions, you need a consultation, you know her prices, her information will be shared in the group chat, so you can reach out to her. We really appreciate your presence here today. Thank you. And
Thank
thank you
you.
everyone for joining.
Thank you so much. All right.
All right.
Bye-bye.
Have a wonderful evening, everyone.